Part of the process of raising capital, like we help people set up a fund or raise capital privately, and we say, okay, well, we have to do your securities filings. And they say, why would I have to do securities filings? I'm not going public. Why do I have to file anything? There are still requirements under a number of different statutes that make you basically have to do certain filings, both on a state level and on a federal level. So on the federal level, depending on what type of exemption you're falling under, so remember, under securities law, you have to either, when you're selling a security, whether it's an investment in stock, an LLC, investment contract, whatever it is, that security to be sold has to either be registered with the SEC or you have to find an exemption. So the most common exemptions, crowdfunding, regulation CF, private placements, regulation D, regulation A is kind of a mini IPO. Those are the most common ones. The most common way people privately raise capital, regulation D, and within regulation D, rule 506B. So whether it's rule 506B or 506C under reg D, you still have certain filing requirements. I'm not get into, so like reg A, you basically are filing, it's a mini IPO. So you're actually filing something. It's an offering statement, basic registration statement, sort of, with the SEC that they review. So there's early filings that you do in a Reg A offering with the SEC. So that's already kind of part of the process. So I'm not even going to talk about that. In Reg CF, you have Form C, which has to be filed essentially prior to the offering. And Reg CF is not used that often anymore. It was supposed to be a big hit and it wasn't. But Reg D still remains 94%. At least 506B is like 94% of the private capital raised. So under Reg D, you are required to file what's called a Form D. That gets filed with the SEC. Very easy to do. It's electronically can be filed. It's a couple of pages long. Basically, what it does is, and it has to be filed within 15 days of the first sale of a security. So when was the first sale of a security? That's kind of based on the facts. So if you basically have an offering, you're raising some money, first investor comes in, you take their money, they sign a subscription agreement, you start using their money or you put it in your operating account to be able to use it. You've probably accepted it, and it's probably the sale of a security at that point, starting the clock, where you have to file within 15 days that Form D, even if all the other investors aren't there yet. If, however, maybe you put it into an escrow account, you set the money aside and you haven't accepted their subscription, it's being held like in trust or an escrow until like a closing date, then the first sale of a security may not be until the actual closing date, where you accept the subscription, you take their money, you transfer it to your operating account, then that might be the potential start of that 15-day clock. So once that clock starts, what do you have to do? You have 15 days to file the Form D with the SEC. It's a couple pages. Basically, what's the name of the issuer? And the issuer is the company raising money. So that's the LLC, corporation, whatever it is that raised capital. And you put in, okay, the company, some basic info, the company, the address, phone number, how much money was raised, and how much you pretend or propose to raise. So you were trying to raise $5 million. So far, you've only raised 500,000. There's two different line items you put in there, trying to raise five, only raised 500,000. And we've accepted 3 investors so far. They're all accredited or some are non-accredited. Check the box. Is this a 506B, 506C? What type of exemption are we relying upon? You sign it. It asks if there's any kind of commissions being paid. Usually, unless you have a placement agent, somebody who's like registered, licensed, securities broker dealer, those amounts would go into those parts of Form D. Otherwise, it's a pretty straightforward form. Gets filed electronically. It's not reviewed to be accepted. It's just filed and done. And the SEC has it now. It's publicly available. Someone can search sec.gov and find under your company name that you filed a Form D saying you're trying to raise $5 million and you've raised 500,000 so far. So they can find that publicly. Now, that complies with federal law. You may have to, if you have an ongoing offering like a fund, you may have to update that or amend your Form D, maybe on an annual basis. Just kind of depends on the facts, if you have a fund set up, what the structure is. So you may have some ongoing compliance, but usually once you're done with your offering, if you filed the Form D and later you close the offering, as long as it's within a certain window of time, you probably don't have to even do another filing to amend it. You're done. So that's on the federal level. On a state level, there's something called a blue sky filing. Now, blue sky, it got that nickname just based on a Kansas state case, or I don't know if it was federal or state, I don't remember offhand, but it was in Kansas, the state of Kansas, and it had to do with something with blue sky, and that's where the name came from. But it has to do with, okay, do you have to file state securities filings when federal law overrides any kind of state law on most issues? And the Securities Act even says federal law preempts or overrides state law when it comes to securities. So if you issue something under Reg D and it's exempt, it's also exempt at the state level. So sometimes you'll talk to someone who maybe is less experienced, doesn't really understand. Even attorneys, I've heard say this, oh, you don't have to worry about, like, we filed the Form D, we're good. We don't have to worry about anything on the state level because federal law preempts. That's true, but Section 18C of the Securities Act specifically says that state law still applies in some circumstances. So the states can regulate and say that you have to file what's called a notice filing and pay a filing fee in that state. So it still basically it said, okay, federal law preempts, but states have the right to require you to do these notice filings and pay filing fees at the state level. And the federal government said, yes, that's okay. So Section 18 allows that under subsection C, both 1 and 2. And so each state has their own system. Typically what you do, like at our firm, we have electronic versions of all this, plug it into a system, and it basically says, fill in the blank, where are your investors from? Okay, I have 2 investors in New York. I have 5 investors in Florida. I have 3 investors in Texas. Here's how much money I raised in each of those states and some basic information. And then the system automatically electronically files in each state. So a notice filing is the same thing as a Form D on a state level saying, hey, we raised some money from a certain number of investors in your state. Doesn't give the name of the person or their address or anything like that. It's just to put the state on notice that this company brought in some investors from the state. So the issue is it's an investor protection issue that the states have the right to potentially at least oversee. So if I've got, I'm the state of Texas and I've got 100 investors here that put money into a deal in some other state, the state wants to oversee and make sure there's no fraud going on. So Section 18 allows states to pursue fraud claims and kind of misrepresentation and fraud in securities against people filing. It doesn't have to just be the SEC. It allows the states to go after those as well. So you put the state on notice that you raised money from them, and usually they have some kind of filing fee. So this is the biggest issue usually with clients is Form D is free. You file with the SEC, there's no cost. I mean, we prepare it, we include that in our fee that we charge, but there's no actual out-of-pocket filing fee. Now, on the state level, each state has their own system. So some states, it's $1,200 to file it. Some states, it's $300, $200, $400, free. Each state has their own system. So if you have a large offering, like maybe somebody raised a bunch of money under 506C online from investors in 49 states, they could have a $10,000 bill just in filing fees to the state. So that's, can be an issue for clients, but in order to comply, you have to do that. And you also have that 15-day clock, 15-day from the sale of a security in their state. So you have to monitor, when did you bring in an investor from that state? Usually it may end up tying to the Form D, the same timeline. But if it's a fund, an ongoing fund, and you bring people in down the road, there may be an ongoing filing requirement for that state, just depending on how you're set up, what exemptions you're relying on. So this is something you need to pay attention to because, a lot of these states, they may not necessarily be like the SEC, so you may not like, oh, well, why would I have to worry about it? The federal government has given them the power to pursue some of these things, including securities fraud. So if you don't comply, they can still potentially pursue issues against you. And like, for example, if you're late, they are going to ask for more of an explanation, and they can actually initiate enforcement proceedings that prohibits you from raising capital in any other state on a federal level. So that's something that they can potentially pursue against you, not just the SEC. It's not just them. The state regulatory agencies have certain rights to pursue you for certain claims. So it is important to comply with each state and to file your blue sky filings. So that's just kind of a quick overview of, I don't know how quick, but of on the federal and state level securities filings that you may have to do. Again, Reg A, that's kind of different. You're filing to register sort of stock. Reg CF, it's a different form, Form C, that you file prior to even doing the offering. So